move them up in the order. So now we're into the comments from the public, and as I explained, we're going to take someone who, well, let me make a comment about the difference between what we'd like to hear now and what we're going to hear later under public comment. What we want to hear now is comments on Commissioner Stoddard's proposal. Okay, we don't want to hear general comments about oil in general, gas in general. We want to hear comments about the document that Commissioner Stoddard has submitted. If you want to make general comments about how we should proceed or the dangers of fracking or whatever, hold that for the public comment period where there are no limits on or any instructions on what you need, what we're asking you to say. You can say anything you want. But here we want comments specifically on Commissioner Stoddard's document. He said he's willing to make some changes. He wants, and so this is your opportunity to say, here's a change that I would like to see considered by Commissioner Stoddard, and if he accepts it, then he can pass it on to the staff, and the staff will be able to prepare the draft language that we want.
Are there copies of the document?
I don't know, are there copies?
We posted a copy of the document on the website, and Mr. Chairman, we did make extra copies.
So I know that Miguel Suazo was on the list from the last time, and I believe he also fits the criteria of someone who'd like to speak, I think, in general in support, or perhaps in support of this document. So I'll start with him, and then I'm going to ask for a show of hands of people that want to speak in support of this document, and I'll call them, and then I will go to the list. And if there's a name of someone who hasn't identified themselves as in support, I will call that name, and that person can come up and testify. And as Miguel just did, it's important that you come up and sit in the chair here, because that way we're able to record your comments and make it part of the public documents. Go ahead.
Thank you, Chairman.
And introduce yourselves each time you come up so we know who you are. If you want to say something about your background, that'd be very helpful.
Thank you, Chairman Arango, and thank you to the Commission for allowing me the opportunity
Yeah, you're going to have
to speak this evening.
Amplifier is low, so you're going to have to talk right now.
Sure. So my name is Miguel Suazo, and I am an energy and natural resources attorney. And a little bit about my background. I represent wind and solar companies. I represent New Mexicans and folks in Texas and Colorado on water rights issues. And today I'm actually representing Thrush Energy, which is the company who's a real party in interest. They have a property interest and are directly impacted by the outcome of whatever planning and zoning decides and whatever the Commission ultimately decides. In listening to your discussion tonight, I think there's a few points just generally that I can shed some light on because I do practice a fair amount of oil and gas law in a tri-state region. And one of the things that was mentioned was the prudent operator language. In oil and gas jurisprudence, you will find the reasonable prudent operator standard to be codified, millions of times throughout oil and gas law. And the reason why that matters is because that is the metric where courts assess the operations and behavior of oil and gas companies. It's a vague standard, but as an example, if you commit a tort, if you punch somebody, they assess whether or not there were reasonable grounds for you to do that, and they assess whether you acted as a reasonable and prudent person in assessing your guilt or innocence under the circumstances. So it's broad necessarily because situations can dictate the assessment of the legislature and courts to whether or not operators abide by that standard. And there's multiple instances that you could look to throughout jurisprudence. So just a point there. As far as nuisances, that is well codified throughout New Mexico law, and it's a vague standard also because if my neighbor plays Metallica music loudly and I hate Metallica, well, that's a nuisance to me. But if I like Metallica, it might not so much be a nuisance. So in terms of noise, in terms of dust, things like that, that is how nuisances are assessed, and you are correct that it is codified within the broad county ordinance. I do have some specific comments on Mr. Stoddard's ordinance, and I've been charged with assessing, the SOP and the various forms of the ordinances that have been proposed up to this point. And I think it's important to understand that, I can already anticipate one of the criticisms that we're going to get tonight is that this ordinance from Mr. Stoddard is 6 pages in length, and that's not enough. And I would encourage the commission and the public at large to go to the Oil Conservation Division's website and click on rules. And you'll see 375 pages worth of ordinance dealing with oil and gas operation. Behind that, you will get a 300-page guidebook that all operators are given that tells them exactly what they are to do in specific circumstances. And in situations where that is not addressed, they can go before the commission hearing. The truth is that a lot of what's been talked about over the past few months are things that should be taken before the Oil Conservation Division, because that is where New Mexico specialists, as created by statute through the New Mexico Oil and Gas Act, and the regulations that have been developed to enforce that have been developed over the last 70 or 80 years, if not longer. So there's already a huge body of law, and we haven't even gotten into federal regulations. The Mineral Leasing Act, which was passed in 1920, governs operations on federal land, and that is 150 pages. The implementing regulations and guidebooks are well over 1,000 pages, and firms like mine, professionals such as myself, we can only interpret them to a point, but we work with other professionals within these companies, petroleum geologists, petroleum engineers, people that have spent years towards understanding and being on the cutting edge of the science involved in these types of operations. So there's quite a lot that goes into it. Let me get to Commissioner Stoddard's ordinance, because I do have a few notes on that. I think compared to some of the other things that have been proposed, this is the first document that I have examined that touches on things that the county should be regulating within its purview. Just because you can regulate something doesn't mean you should, because the county, like anybody, like anything, has its limitations. I don't believe that there's a petroleum geologist on staff, a petroleum engineer, and I don't think the county can likely afford to hire those types of professionals. However, companies who are in this business and people who work at the Oil Conservation Division and the State Land Office, they do have those professionals. So that would be the more appropriate forum and body to assess some of these things. So let me just say, if you want to add some details to this ordinance, I guess you can, but I'd be very mindful that you go through the voluminous pages of material that are already regulating oil and gas and make sure that there's no duplication and there's no redundancy, because much of these things are already addressed, but it takes time, effort, energy, and thought to go through the existing regulations and verify that what you're concerned about at the county level is not already addressed by the OCD and enforced by people well situated and capable of enforcing it. I think this is a step in the right direction. And the example I'll give you, the OCD has the C-Form 101, and that is developed based upon the various statutes and regulations, but it's one page. Now, this is probably 50 man-hours of work for a company to put this together and submit it to the OCD, and the OCD then verifies that these compliance are met with. And if there's something that they don't like, they can add some direction to that and make sure that it is done according to the standards that they're supposed to follow, because they're charged, just like you, with protecting the health, welfare, and safety of the people of the state of New Mexico. Just as you're charged with the same mission on behalf of the people of Sandoval County. So I would just keep that in mind. And the reason why this matters is because this is the first document I've seen that's clear enough that you could actually develop a checklist for companies to follow so they know what's going on. My client has been waiting here for 18 months now, going on 20 months. And we're directly impacted by the lack of a decision at the county level so that we can move forward. And that's real time, that's real money, that has real consequences. And there are some real benefits which I can get into now or later on in the public comment period. But I do want to make sure that I'm focused on what you would like to know with respect to Commissioner Stoddard's proposed ordinance.
Any questions for Mr. Swam?
Did we want to hear any of from his perspective, the positive impact of the industry, or?
Yes.
Okay, all right. I didn't know if you wanted to wait for the public comment.
Yeah, no,
Okay.
in this period, we're looking for ideas that will guide us through the process of making changes in the ordinance. And so, asking a question like, what do you think where do you have problems would be very appropriate. And
Well, I think
there's
it's
not a limit on the time, because as long as people giving testimony stick to the subject, I'm gonna let them talk, because, you know, we're at this stage now where we need ideas about what changes we're gonna make, and it seems to me perfectly appropriate to ask each of the people that are testifying, what do you want, or what do you not want?
Well, I think it's important that because we've heard a lot of the public comment, which has not been supportive of oil and gas in a lot of ways. I think it's only right that we hear both sides of the story before we start making any decisions. So, you know, if you could just kind of give us some quick points on what oil and gas brings to the county.
Sure.
Mr. Commissioner, are we still open for any further questions or
Yeah, but
discussions?
let's let him answer this one, and then I'll.
Okay.
Well, let me give you an example through my own work in New Mexico. You know, I was approached by an individual, a family who, as they self-describe themselves, they didn't have two nickels to rub together. And 2 weeks ago, they were approached by an oil and gas company in southeast New Mexico, and were made an offer for them to develop their property. What I know about the deal that I was able to negotiate for this family is that they now have enough money to send their 3 kids to college, to pay off their mortgage, and to put a little bit of money in bank for their long-term security. And that wouldn't have happened but for you know, the perspective, I think, on oil and gas operations in that part of New Mexico. You know, you want to talk about schools, I would, you know, venture to guess that many people here are always asking the legislature to, you know, commit more dollars to education. And I think we can all agree on that, but where is that money going to come from? Because this goes to the Land Grant Permanent Fund. There's already severance taxes. You know, oil and gas pays those severance taxes when they extract the product, and that goes directly to the state, and they use that in their funding formula, which the county benefits from. So you can talk about assessing fees and all kinds of other things because of a speculative you know, harm that may occur if they use some of the county services, but if Wells Fargo has a fire, you know, at their facility, I'm pretty sure that they're not charged an additional fee just because they utilize the fire department. Oil and gas operations generate dollars that go to support those services already. And so I would just like to keep, for folks to keep that perspective in mind when they're, you know, trying to assess how to, you know, how to make this process move forward.
James.
Yes. In your presentation earlier, you made a comment about OCD. Okay. I have great concerns because at a public meeting during the process of the Stanbridge hearings, they at the meeting clearly indicated to us that attended that meeting that they weren't able to go ahead and inspect quite a few wells that were out there. Can you address that, in your opinion? I mean, how would the public, how would we as the county assure ourselves that, you know, we're going to have somebody watching and keeping an eye on things?
Sure.
I mean, if you can give us a comment on that, please.
Well, you know, I can speak from the perspective of the operator, and I can't speak, you know, from OCD, you know, from OCD's perspective, but, you know, I do know that they do the best they can. I work for the Colorado, you know, work with the Colorado Oil and Gas Association and the Texas Oil and Gas Association, the Railroad Commission, which is the body that actually assesses oil and gas operations in those states. And, you know, the operator has no interest in any sort of its product, you know, being, you know, touching water or any sort of leakage, because that impacts their bottom line. And so there's very, you know, very impressive measurement tools that they use to assess the well. Now, if there is a leak, if there is something, you know, that's unforeseen, those OCD rules and regulations obligate operators to report that condition to the OCD. So what you're asking is, how will you know? You know, the operator is obligated to report that, and they should be measuring, and 99.9% of the time they are measuring and assessing. But you're asking a different thing. Are there random inspections? And, you know, that's a limitation on the agency itself. I'm sure it wishes that it could inspect every well once a day that could, but that's impractical. So at some point, I think it's a matter of recognizing that these companies have every interest in making sure no product is wasted or escapes, or that their operations are impacted from moving forward on a day-to-day basis, because if there's a time that those wells are shut in, that's a time that they are not, you know, earning revenue to support their continued operations and, you know, support our society at large as we drive our cars and have lights on and everything else.
Questions from Mr. Swanson? Yeah.
Just one question. As you heard the commissioners discuss the ordinance and the points they brought forth, do you have any concerns with some of the changes we're looking to move forward with?
Well, that's why I tried to shed some light on it. You know, I think Director Springfield, you know, looking at this, I think he can see a path to have a document where there's a checklist of things that you satisfy yourselves have been submitted. And I think that's all we're asking for, is some predictability. And, you know, I think this does speak to that. You know, if you want to talk about things that are not in the OCD rules and regs, and they'll tell you about it, noise would be one of them. That is a place where the county, you know, has a direct interest. But if an operation is taking place 10 miles that way, what do you care if it's 55 decibels or 75 decibels? So it's a matter of where you are in relation to something else that dictates some of those things. The other thing that I would say is that it's important for the commission to understand that when you're working with petroleum geologists and engineers, what happens on the surface can impact the subsurface. And the subsurface is clearly an area where the OCD has the ability and purview to issue regulations. And so OCD regulations require spacing units, you know, 40 acres for an oil well and 640 acres for a gas well. And you have to be a certain distance from various lines. Now, why is that? Because the geology underneath you can't see, and even the best professionals only have, you know, a cursory understanding until a lot of investment has been made to understand what's going on below. You need to develop that geologic formation in a way that protects it. And there was a term in there called correlative rights, which is important. That is another term of art in oil and gas jurisprudence that I do not have time to go into. But basically, you have to balance the ability of the various owners of the interest to develop that oil and gas formation. And so these geologists advise based upon their studies where it's most efficient. So one section of it might have a lot of pressure, another might have low pressure, and you want to try and balance it out so that none of that project is wasted, because people do own those interests and you want to make sure and protect those things because of the reasonably prudent operator standard. And the people who you have to pay as a result of producing that product, the mineral interest owners. There's people here in the county, thousands of people, who would get a cut of revenue generated if their minerals are produced. And you can experience this in southeast New Mexico or Texas or Colorado or other areas where people get checks on a monthly basis, and that is their royalty share of that production. So it's not just the companies that benefit, it's also the property owners who benefit from it. And there's, like I said, that would be a huge boon directly to certain people of the county if you know, we're allowed to proceed.
Thank you.
Mr. Soto, I had a question. You had brought up both prudence and and nuisance. Are those words left vague for a reason? I feel staff wants to really narrow those terms down, but from what you said, that they're used in many other statutes and many other laws and concerning, you know, different items. And I was wondering if it would be best to leave them more vague, to bring up things that are unforeseeable.
Sure. You know, I think that, you know, to a degree depends on what the priorities of the commission are. I think in oil and gas development, it's pretty clear what nuisances tend to be and not to be. And it's very much, you know, location specific. So obviously, you know, noise, if it's, you know, by, you know, a more populated area, that might be impactful, but as I mentioned, if it's further away, may not be. And so, you know, I do think if there's utility in having a vague term, because everybody knows what a nuisance is. It's a bother. It's a stress on somebody. It's an impact on somebody. And so what that is can really vary. You know, there's no guarantee that just because you call something a nuisance means that it necessarily is going to be. And if a company has to say, well, you know, I didn't realize that, you know, this was going to be considered a nuisance, how do I get around it? That's where you could create a circumstance where a company would have to apply for that variance, hire somebody like me to come before you and explain the nuance of the issue, and then you're kind of just getting bogged down in red tape that probably doesn't necessarily need to be there.
Just one more
Sure.
question. So I gave you the chance to be positive now. I want to ask you to be negative. Okay. My question is, are you aware of a case where an operator was a bad operator and was held accountable in New Mexico?
Of course.
Could you share just an example and
Well,
what was the outcome of that? How did it go?
There's countless cases of operators, you know, being, you know, labeled a bad operator. But, you know, I think the question is, you know, we're not talking about like a BP, you know, kind of spill. We're talking about, okay, well, a truck tipped over and some product spilled out. And so then that's where the OCD comes in and issues a fine. Now, a major release under Oil Conservation Division rules is 25 barrels, 42 gallons in a barrel. So that is the kind of thing that has to be reported. Now, anything less than that is a minor spill, and you know it's still reported. But then the OCD comes in and says, okay, well, we need to clean it up. What I can tell you is there's not a single instance to my knowledge of the process of hydraulic fracturing impacting any sort of water table, and I think that's important to understand. You know, I'm not going to sit here and say that, you know, this is entirely risk-free, but everything, you know, has an inherent risk to it. The act of driving, the most dangerous thing we do every day, is an inherent risk. But we don't stop driving, we just find ways to do it more safely. And people like me are hired not to worry about what might happen or what could happen, but to specifically help companies understand what they can and can't do so that they can do it in the safest way they can. So I have every interest as a professional and in my fiduciary capacity to my clients to guide them the right way and to work with their professional staff to make sure that it's done as efficiently and effectively as possible. So the most negative I can be is sure there's risks, there's instances of, you know, people getting sued and being called quote unquote bad, but I think that's a relative term that you really have to understand each specific situation in order to assess the, you know, the badness or goodness of the circumstance.
Questions? Okay.
Yes, I've got
Oh,
a
go
question,
ahead.
Mr. Chairman. So with your experience in oil drillers and production wells and whatnot, how many times have you seen these companies just go and leave everyone with a mess? I mean, has that happened? I mean, have you seen that happen? And how frequent is that?
Well, I think some of the things that you hear about where people are left with a quote-unquote mess
Yes.
are circumstances when these wells were drilled decades ago. And some of these things, you know, that were drilled, you know, in the 1950s or 60s or even older. You know, I've represented clients with wells drilled in the 1920s. You know, some of those things, the standards were different. Technology has changed. You know, today, especially after I think 2000 in the state of New Mexico, so I'm not getting my states mixed up here. You know, the state regulatory bodies have gone above and beyond to make sure that nobody is left with a mess. That there's, you know, financial obligations so that, you know, whatever harm happens to occur, which usually there isn't any, the people who are impacted can be compensated. And so that's what I think is important to remember is the law has changed, the science has changed, the standards have gotten better. When you hear things, you know, more often than not, it's things that happened well before we advanced sufficiently enough to really do the job that, you know, we want to do, which is always a perfect job. You know, whether it works out the way all the time, you know, it's you know, you can focus on the negative with anything, but you know, we try and do the best we can.
Thank you.
Okay, thank you very much.
Thank you.
Thank you.
So, let's see, I don't, Laura Robbins, are you here?
No.
Okay. Ben Manette, you want to say anything? So I assume you're going to speak in favor, right?
Yes.
Okay, so let me find someone who's going to speak against. Looks like Grace Shore. These are people from the last meeting. I just want to make
She's
sure
not
that
here.
they have a chance if they're here. Randy Erickson,
I'm here.
okay, but you testified last time, right?
I did. I had 3 minutes.
Yeah, okay, go ahead. You're the hydrologist, right?
No.
No, okay, sorry.
No, I'm not a hydrologist, but hopefully somebody out there is. Chairman, commissioners, thank you. Thank you for your interest in this. I've been into several of these meetings now, and up until last meeting, there really wasn't much discussion amongst you about what about this, what about that, and now I'm starting to hear it, and now that's when you guys are going to get something done. All of this about the taking 18 months, you know, if nothing happens in 18 months, then it isn't like you were doing something but you didn't get it done. I think there's been a lot of months go by where nothing happened. So anybody that says, well, look, you know, this has gone on for 18 months, well, it's gone on for 18 calendar months. But you guys haven't had your nose to the grindstone doing what you're doing now for 18 months. You know, if you do what you're doing now and you apply it for a few months, you're going to get a quality product. And I am concerned about who it is that's so interested in this hurrying up. And the gentleman that just spoke gave me a little insight into that. His statement was, we as the oil and gas industry have been waiting on you guys. And I'm wondering, what exactly are they waiting on? Can they bring to you or to my Director Springfield a request tomorrow to drill just like Sandridge did? I don't think there's anything preventing them from doing that.
Yeah, the answer is yes.
Okay, so what are they waiting on? In my opinion, or if I were them, I'd be waiting on something that makes it a lot easier for me to drill my well. Okay? Well, I and others don't care, and in fact, for anybody that's trying to make money, they can get in line and they can do what everybody else does to make money, okay? They don't need a get out of jail free or go directly to, you know, to the start of the monopoly board thing. So take your time. There's going to be a lot of input, and there's going to be some quality input. And it's not just we don't want it. I mean, there's a lot of us that don't want it, but we're realistic, okay? We want quality. And I think you guys can do it, and I'm proud of you, and I really want you to look to us and to some real experts, the geologist when he can finally sit here, to get the input that sort of counters or actually nuances what you just heard. Because a lot of what you just heard, in my opinion, it sounds good. It may, for the most part, be true. But unless it's 100% true, somebody could get hurt. Let's say that there's a noise ordinance that somebody's living way the hell out there, okay? And there's a 750-foot setback. And the decibel level is 55. Let me tell you what, if that was my house and it's 750 foot and you're sitting out in some place like Placitas where it's quiet, you're going to move, if you have the wherewithal to move. Because you're not going to sit there and listen to that thing going day and night in your ears, driving the wildlife away. You're just not going to do it. So take your time. The other thing about the let's hurry up and get it done is an issue that just came up a day or two ago. And it's really got me and some other people upset, and maybe somebody here can explain it. But we see that there's an agenda item on the County Board of Commissioners, agenda item 8 for day after tomorrow, that is a discussion. Well, let me just read what it's. A request for a motion to publish and post the proposed oil and gas ordinance brought forth by the Planning and Zoning Commissioner Dan Stoddard. That's the legal notice, whatever that means. Why is that commission who has charged you guys with presenting them something, taking a submission from one of your commissioners without any input from you and any input from what's actually happening tonight. This is the first you guys are talking about. Why are they doing that? I will be quiet right now if you want to explain it, or otherwise I'm just going to say a few more things about that.
No, it's
Mr. Chairman, the county commission has always had the power to introduce their own version, whether they consult with us or not. We've tried to be clear on that from the beginning, that they basically delegated to us the responsibility for preparing a draft that they could look at, but that didn't preclude them from developing their own draft.
No, I totally understand that, and I understand that you guys serve at their will, at their behest, and they can do whatever the hell they want. But the deal is, why are you guys sitting here working on this? You know what? Why are you? If what's going to happen is they're going to say, oh well, let's just go do it ourselves, or let's just go vote on this and get it done. And back to my original thing, why? What's the rush? What's the rush? Or we're not preventing anybody from making money. So if they want to come in here and try to make some money, they can put in their application.
Mr. Chairman, Randy, I'd like to address, I'm not at all trying to rush the procedure, but as you commented earlier, we have momentum as a commission. We seem to be, from what you said, and a lot of people talked about at the last meeting, having an ordinance. And I even asked for meetings for once a week so that we could get moving forward. It's not to rush it, it's not to hurry things up, but when you go once a month, we seem to come back, and you stated it, nothing ever gets done. It's like a dog chasing its tail. So in my opinion, this is very important for the community on both sides. And there's no reason why we can't work diligently to get this done and then start taking care of other orders of business that we have. We've had to postpone 2, was it special uses? The meeting we're gonna have today was for 2 conditional uses that we had to postpone to do this.
Yeah.
So there's a lot of other things we have to address coming up, and I'm not trying to rush, but I know we've all had a lot of information from both sides, and as I said earlier, I made a comment, let's meet once a week and let's get workshops going, let's get this thing, let's get it right, and while the momentum is there, let's address all the issues. Because once a month is not gonna get it done. It seems like we start all over again.
No, I totally agree. Some group has got to be really getting down and getting this done. But why is it that the Board of Commissioners would want to get into it? And certainly many of us will be here Thursday night to find out what they're going to talk about. But why is it that it's even on their agenda?
I can't speak for them. I can only speak for myself.
So you don't know?
No.
Okay. Interesting. Okay. Let's talk about the length of the document. I don't think 6 pages is enough, especially when the first page is whereas this, whereas that. But that's not the point. And it's also not the point if OCD has 1,000 pages of documents. The question is, what's the quality? What is it that OCD might not have got in their 1,000 pages that we want in ours? Because we're Sandoval County, and because we want it, okay? We have that right, and we can be additive. Let's be clear, the Mora County decision didn't say you can't put out anything that has anything to do with any law that's already been passed. It says you can't contradict a law that's on the books. You can't take away anything that's already is a law, but you can add to laws. You can say, well, in addition to what OCD wants you to do, here's the other things we want you to do. Doesn't prevent you from doing that, and in terms of non-overlap and not doing things twice, I totally agree with Commissioner Brown. We don't need to restate what's in that 1,000 pages, but if something's missing, that's what ought to be in our 6 or 8 or 10 or 12 or 40 pages. Just one, I don't have to go through the things that Chairman Rango, the things that you brought up, I thank you on, in terms of the things that you noted in the proposed ordinance. I think a lot of us, we're gonna say the same thing, so I'm not gonna repeat that, and I appreciate that you brought it up, and that goes for the rest of you guys. But one thing that nobody brought up was the final article, Article 8, which is enforcement, that states that violations may be subject to a fine in aggregate of $10,000. Just in the meetings I've been to here, I thought I heard from the director and others that the OCD, or at least the state level maximum, is like $200 or $300. Isn't that right?
It's said in state law, but that's right.
Okay, so that would be an additive thing. That, or no, well, that would be actually changing the law, which would be something that we can't do. So we can't actually say, you know, we're going to charge you $10,000. But what we can do is we can say we can take your permit away. And I think that this is a key item in terms of leverage. That's one thing that we can do as a county, is revoke the permit for any violation of anything, if we're including everything in the 1,000 pages of OCD and everything else that we put in on top of that. We can say, you know, if you're not complying with that, we're going to pull your permit.
So that makes a lot of sense, but it's extremely difficult to do under our current ordinance, and it could only be done probably if we use the special use. But basically, when we grant a permission for someone to use land in a special way, for example, to drill an oil well, it's really, really hard for us to say, oh, by the way, we changed our mind because you violated certain things.
Well, let's
because
just say,
that permit attaches to the land, not to the operator.
well, let's say that,
I mean, we basically say this piece of land is a place where an oil well can be drilled, and so then somebody goes ahead and drills. But it's the land that's designated as a place to drill an oil well, not the operator.
so are you saying that our ordinance couldn't have some metrics in it in terms of, let's just say, methane emissions, and let's say there on your well there will be no methane emissions over the XX of YY, you know, or whatever.
We can have a standard, and we can have penalties and inspections and all that, but the narrow thing that you said, which is we can withdraw the permit, that it's not impossible, but it's really, really hard.
So you're saying that if somebody violated, let's just say, a methane emission that was clearly stated and it was clearly documented that they were in clear violation of it, we would have a hard time pulling the permit?
Yes. Well, I mean, the county attorney may want to comment on this, but
When it comes to enforcement and things like that, you have to be really careful with due process rights. Because once you give a permit to somebody, they do have some rights with that. And so you have to make sure that you follow their due process rights. The other home is, if it's an OCD permit that we were trying to revoke, OCD granted that permit, not the county. So if we go with this ordinance and make it a permissive use, we're saying they can use that we're using OCD's permits. And so there again, it would be hard. We can make mechanisms for enforcement in our current zoning ordinance, for example. If somebody has a bunch of, the example you gave was a bunch of used cars on their land, we can file in court an action against that. But we have to go through the whole due process rights because they do have certain rights on their land.
Okay, thank you. So what I heard is if we wanted to figure out a way to do that, we could do that. And I'm going to count on you guys to figure that out.
Mr. Chairman, if I could interrupt for just a second, Randy, I guess I'm concerned that now we're talking about something about, let's say if we pick some standard methane release, do we as a county have the ability to verify and enforce that? Do we have that capability?
Not now.
I'm glad you brought that up because I almost forgot. And yeah, Well, we don't, because we don't have the people, we don't have the money, we don't have the trucks, we don't have the monitoring equipment. But hey, if somebody, well, I probably don't need to finish that sentence, do I?
That's my concern, is that we should not write anything that we can enforce. That's the point.
Mr. Chair, I'd like to comment along with that, and that not only that we can enforce because of several reasons, mainly monetary. We have to be able to have the monies in place to enforce whatever ordinance we have or put together.
Absolutely.
I mean, that's
I'm not
go
gonna
hand in
wanna
hand.
raise taxes, and we're not gonna want you to raise taxes, but
Whether
that
it's
doesn't mean
monies
that the industry,
as part of a fee to pay, the planning department to process these notices,
there could be
whatever it
annual,
is, we have to
there could be a
identify
monitoring
it
fee.
and address it.
There could be a monitor and compliance fee. And in fact, I'm sure in a lot of industries, let's say the airline industry, there are lots of fees like that. So why oil and gas would not have to pay something like that and the other guys do? It's not out of the question.
So there's a long list of people who want to testify.
I
I
know.
don't want to cut you off, but the
Yeah,
longer you
won't.
speak, the less time there's going to be for
I
others.
know, it's been a real pleasure. Just one question. I just watched a movie called Split Estate, and I'm gonna give you guys the opportunity to watch it at home as soon as I get my hands on a few copies of it. It's a horrifying movie. I'm not gonna go into that, but apparently in the western United States, it's true for almost all landowners that they don't own the mineral rights underneath them. Is there a map, is there some documentation that the county has that, in terms of the private land, that describes who owns, on any particular parcel, who owns the mineral rights? So we could understand, basically who it is that has got the interest in drilling.
Michael, is there an answer to
We
that?
currently don't have any map like that. We can look, we can research just like everybody else, so we'll research that and report back.
Okay, that would be, okay, thank you very much.
Thanks. Thank you. So now, Baxter in favor and then Manette.
Mr. Chairman, I think I'm going to wait till item 9, public comment to speak.
Okay, fine, okay. Let's see, so is there anyone else that wants to speak in favor? Okay, then I'm just gonna start calling, I assume that everybody else has signed up is against it, so I'll call names and just come forward. And remember, we're gonna cut off.
Yes, I'd like to speak in favor,
I
please.
can't hear you.
I'd like to speak in favor, please.
Yeah, I'm gonna call based on what
Okay.
this says.
Okay.
Oh, you wanna speak in favor? Okay, come on. Sorry.
And I am on the list for public comment, please.
Yeah.
Thank you, Chairman and Commissioners. My name is Amy Barabee, and I work for the New Mexico Oil and Gas Association. We have nearly 1,000 member companies who employ 100,000 New Mexicans and provide a third of the state's general fund for public safety, healthcare, education, including, I know that education was brought up earlier, $47 million to Sandoval County schools in fiscal year 2016. Both federal and state governments already heavily regulate, as has been explained and discussed here today, the oil and gas industry. And they have the resources necessary to do that. Sandoval County has been struggling for more than 18 months, nearly 2 years actually, to find the best path forward that addresses concerns of community members and is business friendly in keeping with your hard-earned reputation as a county. Witnessing this struggle, combined with the industry's commitment to being a good neighbor in our communities, led me to want to speak with you this evening. Regulatory certainty is key to success for both the oil and gas industry as well as your community members. Despite the fact that our industry is already heavily regulated, as I stated, by both the state and federal governments, having reviewed Commissioner Stoddard's ordinance and experiencing the angst that you hear again tonight, but you've heard before, due to the regulatory uncertainty currently in Sandoval County, industry stands in support of Commissioner Stoddard's ordinance. This ordinance provides clear direction for business seeking to operate in your county, eliminates confusion about the permitting process, while focusing on the issues which the county has jurisdiction over and addressing the concerns that we've heard repeatedly from community members. That includes the setback requirements, noise, emergency response, your roads, and the lighting and visual concerns. So I just wanted to tell you that we are in favor of this. Thank Commissioner Stoddard for bringing forth a solution after, again, nearly 2 years of going through this. So thank you to each of you for your thoughtful consideration in moving forward something to the commission.
Any questions or comments? Okay, yeah, we very much appreciate your being here, because it's notable that in all this time, we've never actually heard from the Oil and Gas Association, so please feel free.
Happy to. Thank you for having us.
Submit any written comments.
Okay. Okay. Thank you very much. You know, one thing I will leave with whoever you want is, and I did, so there was a workshop in May for the entire commission, and handed out at that workshop was the breakout of the monies for Sandoval County, and I think that might be helpful. I'll be happy to email, and I have before Director Springfield, all the materials that were provided at that workshop. So I'll follow up with that.
That was distributed at the workshop that the Board of County Commissioners had, but I'm not sure if it's ever been posted anywhere, so it'd be fine if you send it to the planning and zoning staff, and they can make sure it's posted.
Thank you.
Okay, so anyone else who wants to speak in favor? Yes. Well, let me actually, the next one is against, so let me go back to the list. Alan Friedman. And again, just remind people that we're going to cut off at 8:30, and so to the extent that you can condense, give more people an opportunity to speak.
Chairman Rango, you put this as in who's for it and who's against.
Microphone, please.
Excuse me. My name is Alan Friedman, and I live in Placitas. I'm director of the Anasazi Trails Water Cooperative. You put this in who's for and who's against. I'm for having an ordinance that allows oil and gas drilling and protects the citizens of the county. So, does that make me for or against? I don't know. Okay. I want to point out something that you all already know, but that the Board of County Commissioners is mandated and has broad authority to enact ordinances to provide for the health, safety, and welfare of the community. You all know that. And that the provisions of the Sandoval County Comprehensive Zoning Ordinance are designed to promote the health and general welfare of the county and to protect local water resources. That's a concern of mine. The draft oil and gas ordinances we are considering, both the one developed by the county and Commissioner Stoddard's, are both silent on the role that the county can play in the issue of water protection. Commissioner Stoddard, the NMED has no authority on a role in protecting water as it relates to oil and gas activity. The only agency is OCD. And conversations with the OCD, and I'll give you a direct quote from the director: any aquifer contamination as a result of oil field operations is the responsibility of the OCD. And OCD contends that groundwater contamination issues that occurred during drilling, hydraulic fracturing, or producing operations from wells are very rare. By OCD rules, groundwater monitoring wells are not required as part of the normal completion or operation of an oil or gas well. So if OCD never monitors water for contamination, they'll never find any. And what does very rare mean? And I've attached in the comments I left with you a paper on the integrity of oil and gas wells published in the Proceedings of the National Academy of Sciences. And this was in the area of oil and gas activities that was extensively studied. Over 6% of the wells studied leaked. That's 6 wells in a 100 well field, or 60 wells in a 1,000 well field. These wells could be sitting over aquifers that are the only source of water for hundreds or thousands of people in Sandoval County and adjacent counties. As you've seen through public comment at your meetings and on the ordinance and with the Sandridge application, the public is intensely concerned about protection of our water. Like Sandoval County, Rio Arriba County has substantial oil and gas activity. Rio Arriba requires groundwater monitoring wells and ongoing monitoring. Indeed, some oil and gas producers voluntarily install monitoring wells, and monitoring allows the county or the producers to catch problems before they grow into disasters. So monitoring wells should be required in our ordinance. Yes, and I agree, oil and gas are now important to the New Mexico economy, but are not more important than quality fresh water. Water is and always will be indispensable for life. So commissioners, in our oil and gas ordinance, do your mandated job to protect our water.
Hey, Beth Moore Love.
Oh, yeah, that other gentleman.
Excuse me?
That-
Oh, yeah, okay, sorry.
Chairman, members of the commission, thank you for having me here today. My name is Jason Espinoza, and I'm the president and CEO with the New Mexico Association of Commerce and Industry. So we serve as the statewide business advocate, and we represent businesses, both big and small, across every industry sector in every corner of the state. And I just want to touch really quickly on how we come up with our policy positions, because I think it's important. We are sort of a grassroots business organization that we develop our policy positions from the bottom up. Our membership drives what we do, not our board of directors, not a single industry, but really all of our members, from small retail cupcake shops to energy producers to electric utilities to insurance companies, whatever it may be. We have broad membership, and it's actually interesting to note that 50% of our membership is 25 employees or under. So we really are reflective of the complexion of New Mexico business across the state. When we talk about the regulatory environment here in New Mexico, the one thing that comes up, no matter the size of the business, no matter the industry that you're in, it's predictability. We are asking folks across the business community to make investments in our community. And to make that investment, they want some stability, some predictability, so that the rules are not changed on them, that they understand the rules. And that is really the thing that we're looking here, and really want to thank Commissioner Stoddard for the work that he's put into this ordinance. We really do believe that it provides a clear framework and predictability so that employers understand what the rules are. They can make sure that they fit within those rules and then give the documents to the commission. So we do support the ordinance as introduced by Commissioner Stoddard. Again, I think it does provide a great framework, predictability for everyone across the industry in terms of the investments they make. So just wanted to come here and share with you where our members stand across the state in terms of the ordinance. And this is really looked at as a statewide issue, because it does, again, the oil and gas industry does affect the state, every county, every city, every school system. And so the statewide business community, we do support the ordinance. Thank you.
Thank you. Quick question. You mentioned small business. Can you kind of give us some kind of idea of how many small businesses are in the oil and gas industry?
So I'm not gonna present myself as an expert in terms of the oil and gas industry. In terms of our membership, There are a lot of small producers, in terms of our membership. That's where we tend, our membership is focused, because there are a variety of different producers, a variety of different companies, and we think this does provide the framework for everyone.
Any other questions? Okay. So now, let me call again Beth Moore Love.
Can't hear you.
Beth Moore Love. This next one is hard to read, but I can read the first two. It looks like Mia King, and I can't read the last name.
Flaherty.
Mia King, Flaherty.
Oh, I'm sorry.
Okay.
Hi, thank you, Mr. Chair and Commissioners. My name is Maya King Flaherty, and I'm the Public Lands Fellow for the Sierra Club Rio Grande chapter in Albuquerque. And this past weekend and last week, the Sierra Club and Earthworks Oil and Gas Accountability Project, we hosted a film showing of Split Estate, which I think you heard mentioned. And I highly recommend that you watch this film because it's very illuminating in terms of the true impacts of oil and gas in communities throughout the Southwest. And I just want to say that this commission has heard quite often from many residents, some tribal reps, and some public officials about the need to slow this process and develop a balanced and strong ordinance, one that protects our air, our water, and public health. The ordinance brought forth today is clearly a pro-oil and gas ordinance, and it appears to be written by industry and incorporates minimal safeguards. This commission has a legal responsibility to protect the public against nuisances posed by industry, and the ordinance discussed here does just the opposite. Furthermore, I believe this ordinance should be removed from this Thursday's County Commission meeting and should not be voted on to be published and posted. I heard that discussed a little bit, but from my understanding, if it's published and posted, then it can be voted on by the County Commission, which I feel would circumvent your responsibility as a commission to develop a strong and well-intended plans that safeguard our natural resources, public health, and protect our families. I think it's important always to do the right thing and listen to your constituents who have been very clear and vocal that they want to see an ordinance that ensures water and air protections, addresses traffic impacts, requires robust energy plans, incredibly deals with noise and light pollution. In the northwestern part of New Mexico and rural areas that are managed by the BLM, Bureau of Land Management, they actually do require noise levels be at or less than 48.6 decibels from facilities that are within 100 feet of public buildings and homes. And this is both on public and tribal lands. And please do not consider this ordinance here. And continue to hear from professionals that aren't associated or affiliated with New Mexico Tech, which are obviously pro-oil and gas, but from other professionals who can speak about it as well. And I think it's okay to take another 18 months to develop real and balanced protections.
Thank you. So last name on the list is Janice Rousseau.
She's not here.
Okay, so now we're on to today's list.
Mr. Chair, my name was on this last week.
No, this was the last week's list.
Yes, it was. If you remember, I stood down so others could speak.
Yeah, that's right. I don't see your name, but all right, here's the list if you want to look at it.
Mr. Chairman, he did ask to defer to others until the end of the
Oh, that's
comment.
okay, fine, okay, come on.
Thank you, Mr. Chair. My name is Mike Neese. I live in Cositas also. There's a lot to talk about. I thank Mr. Souza for bringing up some points. Some of those points are thousands would benefit from the taxes, but hundreds of thousands would be harmed by any environmental damage, while those thousands benefited. Financially only, they wouldn't be able to drink their water. Mr. Souza says that what happens on the surface impacts what happens on the subsurface. The same as the reverse is true. What happens on the subsurface can greatly affect us on the surface. And we must address those issues. This document, I'm unclear as to whether there's going to be a vote tonight. So if anybody could please clarify that for me, because on the agenda, the revised agenda, it says oil and gas exploration and production issues to be considered. Is a vote, does that fall under the definition of considered?
That's why we set aside half an hour, because one of the things we have to decide is, are we going to vote tonight?
Yeah, thank you. And so when we do an agenda, I think that we should be more specific as to what's going to happen. Discussion and vote. That's better than considered. It's a little misleading when the public is being bounced around anyway. I mean, we've got to go to this meeting on Thursday night now because Commissioner Stoddard has brought forth. I'm not even sure what that means, brought forth. Is that a legal term? Because now it's at the county commission and the planning and zoning commission hasn't even voted on it. So is this keep away? Because I feel like it's keep away. Now, it may be keep away from the planning and zoning department too. Maybe they're feeling the same way that the public is feeling. This is wrong. This job was given to you. It's your job to keep. It's your job to do. And I think that you should respectfully, and I'll go on Thursday and say this, to ask the county commission to let you do your jobs. Or maybe you guys should just go home. We should all go home and only go to the county commission meetings. It scares me that the public is being treated this way. So if we are going to vote, I hope that you will vote no on this document. It's going backwards. The department had a 27-page document. Let's combine these 6 pages to that, and we've got a better start. But also, at the last meeting, there was discussion about individuals in the public that wanted to participate in the writing of a document, and we are participating in the writing of a document. Here are 60 pages that we hope to have ready for you at the next meeting, or prior to the next meeting, or prior to your workshop. So this document addresses certain things that your 6 pages do not, Commissioner Stoddard. And I'm not saying that your document should not be included in a quality document. I think that it should. But it is not a quality standalone document. So this document that we are working on and with suggests, there's been a lot of conversation about, well, we can't do this, we can't do that, because it's already being done by OCD or ED or the federal government. Well, okay, let's include, instead of saying we can't do that, we've got to dance around this thing, how about we include, and all we do is write something like, the regulatory jurisdiction conferred on the county is concurrent with and in addition to the regulatory jurisdiction of the federal government and the state. We include all of that, and if they don't, if OCD doesn't regulate over that, and they conveniently, because of whatever political situation, they ignore it, we have the option. And if the county doesn't do it, because it's in this document, at least possibly the public has a viable suit. And then we can bring Mr. Souza in to defend his client. Fracking has changed everything. So this document, the 6 pages, about the fifth whereas, the commissioners recognize that oil and gas development has occurred within Sandoval County for over 50 years with minimal impact on the county and its natural environment. Well, I don't think that there's very many people that will agree with that. I think that a good portion of this county already disagrees with that. And this kind of a statement is, first of all, it's not true. And it doesn't apply to every individual in this county. It excludes huge areas in this county. Can anybody tell me what the decimal level of a Harley Davidson sitting next to me at a stoplight is? Thinking it's about 55 decibels, and I'm not going to listen to that all night long, 24/7. So we need to, and insurance. Insurance and bonding is inadequately addressed in this. Page 3, number H, refers to 19.15.5 NMAC. Well, actually, that has about 4 words that sends you over to 19.15.8, and it does not cover environmental accidents, period. It doesn't even cover, it excludes damage to cattle from surface spills. And the total fine is something like, or this is on the bond, the total bond is only $15,000. So we're talking about $100,000, am I correct? No, $1 million liability insurance that probably doesn't include any environmental damage whatsoever. I've told you before, I'm a general contractor, and my insurance policies are $2 million, and I'm not going to poison the environment of possibly 800,000 people drinking out of the Albuquerque Basin. So this does not adequately address water in any way. I mean, it does have a paragraph with respect to water that allows the industry to address that, and maybe some possible SOPs at some point, but it's totally inadequate. And as a contractor, I've told you before, I've got to prove 100-year supply of water. Mr. Manat back here, maybe he can tell us where he's going to find a 100-year supply of water out in the Rio Rancho Estates area. So I've got a lot more to say, but I think I've said enough. And so please, vote no. This is not a quality document. When we add this to it and Mr. Springfield's 27 pages, we're going to have something. Thank you.
Amy Barabee, I think, B-A-R-A-B-Y.
I spoke already.
Oh, okay.
Yeah, thank you.
Okay. Michael Ward.
That's me, but I would also like to wait until section 9 public comment.
Okay, it's probably going to be fairly limited, but that's fine. Well,
I can keep
because I called you already, I'll make sure I call you during the public comment period. Let's see, looks like Daisy Coates, maybe, K-O-A-E-S.
Thank you.
My name is Daisy Cates, and I've lived in Placitas for about 40 years. I'm just going to read something that I wrote. I'm going to read something that I wrote here. Thank you for listening to the public on this very important issue that has far-reaching ramifications for this county and for the entire basin that depends on the purity of our aquifer. My understanding is that this includes Albuquerque. There are communities in Colorado and northern New Mexico that have been decimated by the oil and gas industries. I am very concerned that the County Commission and the P&Z will wait until they are fully educated on the subject and can formulate an ordinance that protects citizens to the fullest extent possible from health and environmental issues, as well as providing protections for their property and quality of life. The county can provide regulations that are more stringent than those of the state and federal governments, and incoming funds from these operations can surely be dedicated to overseeing compliance. The ordinance that is currently on the table is inadequate as it stands. We understand that the county is anxious to receive revenues generated from oil and gas drilling and is also being pressured by these interests to move forward, but there is too much at stake to act hastily. There are obviously very serious issues surrounding fracking operations which have already caused it to be outlawed in 3 states that want to avoid contamination of their water supplies. We need to pass an ordinance that is the best possible protection for all who live in Sandoval County and those in New Mexico who will be affected by our decisions. I believe you should be fully satisfied that if a fracking operation were to be installed in close proximity to your own property, you would be completely comfortable with the ordinance you have supported. Thank you. I would like to add one thing, because I keep hearing that the county has no money to oversee compliance, to do a variety of things that would support the regulations that you might provide. And then I hear that there's millions and millions of dollars coming into the state from oil and gas. So if there's millions and millions of dollars coming into the state from oil and gas, how come the county has none of that to use to regulate compliance or to oversee compliance? I don't understand that.
Thank you. Looks like Jim Pettigrew.
Good evening. My name is Jim Pettigrew. I live in Placitas. Thank you for holding this public hearing this evening. It's been a little confusing, and Chairman Arango, you brought this up also, as a couple others have too. The agenda said it's a public hearing to review the ordinance concerning the oil and gas proposed ordinance. There are actually 2 ordinances posted on the website, Commissioner Stoddard's ordinance and another one that was identified as the staff ordinance. So I wasn't clear on which one is actually being considered tonight, although it appears to be Commissioner Stoddard's ordinance that we're talking about, and that's fine. It's also not clear whether it was up for a vote tonight. As someone else noted, wasn't quite apparent what was to be decided or discussed tonight or how far it would go. And also, I'm concerned that it's also on the agenda for Thursday night at the County Commissioners meeting. So does this make this whole meeting tonight moot? Will this exact ordinance be brought up Thursday night? You may not know that because you're not the commission. But if this ordinance is being discussed tonight, I do have a couple comments. My comments are both on procedure and the substance of the ordinance. I'll just say my background is 30 years as a real estate broker. I now work in the solar electric industry. I've served on your side of the bench in another state, so I appreciate the time tonight. I'll also note that none of the folks that have spoken for the ordinance tonight lives in Sandoval County, as far as I know, and I believe all 3 of them were paid to be here tonight. The ordinance as written has some real issues, some of which you all have identified already. It's not clear still to me, and maybe to you all as well, what this actually provides for. My reading of the ordinance shows me that it is simply a notice requirement where the operator has to fill out a list of information, supply it to the planning division. The word application was used earlier, but application is used once in the ordinance that I see. But I think, as you said, Chairman Arango, it appears that once the permit from OCD is obtained by the operator, then they fill out this notice requirement as the ordinance provides, as long as the department or the division of planning and zoning says that the notice is complete, that's it. I see no provision in the ordinance about deciding whether any of the issues brought up in the list of requirements is sufficient or they get debated. The only provisions in the ordinance as written seem to be, is the application complete? Is the notice complete? That's it. As you said, Chairman, the court is going to look at the text of the document. And Mr. Stoddard, you keep referring to the criteria listed in the ordinance, but they're pretty vague at best. The noise control portion that's been brought up, it suggests maybe a noise level not to exceed 55 decibels has been brought up. Whenever you specify a decibel level, it has to also specify which decibel scale is being used, A, B, or C. It also needs to specify at what distance. 55 decibels 10 feet away from it is way different than 55 decibels 10 miles away from it or 100 feet away from it. So that doesn't work as written. 55 decibels all by itself is relatively meaningless. Section F says that the applicant needs to identify the roads to be used and the estimated amount of traffic. Fine, these are the roads I'm going to use. I expect this many vehicles per day or per week. As long as Mr. Springfield says the application is complete, it doesn't seem like anyone gets to say whether that's appropriate or acceptable. There's no level of review and approval that I'm reading in this ordinance. Under light direction, it says, to the extent practicable. Boy, that is a can of worms defined. Under water protection, the operator will take reasonable measures. Same sort of idea. And you already brought up the idea of the reasonably prudent operator. That's been addressed already. The conflicts section says that the county will defer to the authority of state and federal agencies. I would say, step up. We can make rules that are more restrictive than federal or state rules, if that's the pleasure of the county and the commission. I encourage you to reserve the right to say no to bad ideas. The substance of the ordinance ought to comply with the comprehensive zoning ordinance that it purports to amend. The comprehensive zoning ordinance says that it's designed to promote the health and general welfare, not maintain the status quo, promote health and general welfare, make it better, to secure us from dangers, to protect local water resources, to conserve the value of our property, and provide for compatible development. If I can read between the lines at the intent of this ordinance, I would say it falls far short of doing those goals of the comprehensive ordinance. I think it is meant to open up Sandoval County to easier oil and gas development, and I, for one, am not in favor of that. Thank you.
Okay, Linda Hayes.
I'm actually not speaking about specifics in the ordinance, so.
Yeah, okay, then hold off. I'll list you for public comment. Benton Howell?
Yes, I'm Benton Hall, and I live here in Bernalillo Township.
Can you speak more into that?
My name is Benton Howell. I live here in Bernalillo Township, and I have attended many of these meetings before. As far as the ordinance that was presented tonight by Commissioner Stoddard, I I do think it's a good thing that he has tried to write one, and he's going to make progress and probably will be pushed forward. But I think there's so much to do in writing an ordinance like this that is actually going to be effective, that it would be better if the commissioners would consider an ordinance that already is working and actually works in the best interest of the people very well. And some of the things that would have to go into Commissioner Stoddard's ordinance would actually concern the way you might be able to do baseline measurements, for instance, of the soil near the well, of the water in the area, so that when actually there is some problem where you detect chemicals in the soil or some water contamination, that you would actually be able to go back to a baseline measurement. And I don't think that gets addressed in yours, because I think you assume that is in the New Mexico OCD set of regulations, and it's not. And so one of the problems that we would have by the county depending on OCD to cover this is that it wouldn't be done. And so I think that there needs to be a better ordinance that you all use that already has shown that it's effective. And another thing that your ordinance doesn't do is it doesn't cover an environmental impact statement. And this is a big deal to actually find out what would actually be needed to know when you're impacting the environment, and do careful analysis and find out what the baseline environment is, so that you can say, okay, if I spill 100,000 gallons of benzene in this spot, will it change the environment? Well, you have to know what was there in the first place. So you need an environmental impact report like you have in the Santa Fe ordinance. And so what I would suggest, instead of spending a lot of time trying to come up with a very well-written ordinance that covers a lot of these issues, use the Santa Fe ordinance as a starting point and take from it what would be useful for Sandoval County. And that will go faster. That will go faster and make this whole thing work out better. So that is my suggestion. And once again, I think you did do some valuable work, and I just think that there's a much better way to go with this. Thank you.
Thank you. I think it'd be helpful for the public to know when we reconvene. Do you want to hear more testimony on Commissioner Stoddard's ordinance, or do you want to move to our discussion of it?
I think we probably should move forward with our discussion.
Is that agreeable? Okay, so what we're going to do is we'll take a 10-minute break, just to give people a chance to stand up and talk. Then we will move to commission discussion of what we're going to do next. And then after that, we'll have the public comment period. It'll be limited to 3 minutes, and the people we'll call will be Ben Manat, Michael Ward, and Linda Hayes, all of whom have been called already and decided that they prefer to testify in the public comment period rather than specifically to Commissioner Stoddard's ordinance. So let's take about a 10-minute break.